So why do I need probate? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today let's take a quick look at the probate court process, a real general overview of what happens so you can get an idea of why you need probate. So if you've done any research or done any estate planning, you've probably heard the term probate. And what probate is a name for your local court system that deals with people's estates and liabilities and assets after they're gone. So once somebody has died, there's a special type of court. So for example, in New York, it's called a surrogate's court. Here in Minnesota, it's called a probate court. Wherever you are, there's maybe a different name for it, but it's all the same type of court, and it's considered a probate court where we deal with the assets and liabilities of somebody after they have died. And so once somebody has died, there's usually 6 general steps that we have to go through. Now, I have to give the caveat before we get started that I'm talking from my experience in Minnesota, New York, New Jersey, and Connecticut. If you live in a different state, the steps may be a little bit different. The process isn't always the same, meaning you might have very specific state rules that apply only to your residents. But we're going to look at a generalized 6-step process of what most states will have you go through. Step number 1 will be to file the will and the death certificate with your local court. And usually a petition will be filed with it. So if there's a will, the petition is usually pretty straightforward. It says, so-and-so has died. Here's a copy of the death certificate. Here's a copy of the will. This person has been appointed as the executor or the personal representative, and we're asking the court to formalize that appointment. Now, in cases where we do not have a will, we still have a petition that has to be drafted and submitted to the court, and usually along with that, there's going to be more documents that are needed. The court's going to have to figure out who is the appropriate person to be the executor or personal representative. So with a will, you get to pick that person. Without a will, then the court is going to have to decide who is the person that's going to be in charge of the estate, and they've got to get everything together, distribute the assets, pay off liabilities, as we'll see in the next few steps. So once we've filed the will and death certificate and we petitioned the court, the next step, number 2, is we have to notify the family members and the creditors. So notifying family members is usually pretty easy. We have a notice we send to them, whether it's by mail, whether it has to be by personal service, depends upon the nature of the estate. If you have somebody who's died without a will and we're not sure who actually family members are, we may have to submit a full family tree to the court so we can make sure we know who are the family members who may be entitled to inherit from the person's estate. And then we also have to notify creditors. So notifying creditors is why probate court records are public. And if you've never dealt with this before, you'll often find that after somebody dies, you will start getting a lot of notices from people who believe they are owed money by the person who died. The way they know that person died is that they have somebody in their company. It's probably not a person these days, it's probably a bot or some kind of AI program that is consistently going through all the new probate court filings, and whenever it comes upon a name that is a customer of that institution, it sends a little red flag up and then lets them know that John Smith is deceased and may owe us money, so we need to send them a demand for payment. Step number 3 is going to be inventory the assets. So whether again with a will or appointed by a court, what we have to do next is figure out what the person who died had at the time of their death, what were their assets, what were their liabilities, and we have to figure out whether or not there's any tax concerns. And that is step number 4. So we have to pay our debts, we have to pay taxes if they're owed. Regardless, you're going to have to do a final tax return for the year in which the person died. So if somebody died in January of 2024, they still need to file their 2024 taxes in 2025, and that becomes the role of the executor or the personal representative. So we file the will, we petition the court, we notify heirs and creditors, we inventory the assets, we pay our debts and our taxes, and after all that's done, we can finally distribute whatever's left to the family members. So we distribute the assets. If there's a will, the will usually say what happens as far as who gets what. If we have some charities that you want to leave money for, that will be in the will as well. So after we've gone through these steps, we're able to distribute the assets. And then once all this is done, we come to the final step, step number 6, which is we close the estate. This is usually done by filing an accounting or other kind of table with your local probate court that shows what the assets were, what the liabilities were, who's been paid, what debts have been paid, and what the distribution of assets were. And at the end of the day, at the bottom corner, you want the number to be 0, which means all of the assets were rounded up and they were all paid out where they had to be and there's no money left in the estate, so now we can close it. Now my clients will often ask me, this sounds pretty complicated. These 6 steps seem simple from a video, but it sounds like there's a lot of work, and there can be. And the question then is, how long will this all take? And in the true lawyer's tradition, we have to say it all depends. In some places, we have informal probate procedures where we can wrap this up in a few months. What usually will take some time is after somebody is appointed as the personal representative or the executor, there's a period of time for creditors to make claims against the estate. So we have to wait before those claims have been made, and once that period expires, the creditors can no longer make any claims because they're out of time to do it based upon when the estate was opened. So the estate process can be short, like 5 to 6 months, or it can be long. If you have a drawn-out litigation, if we have family fighting over who gets what, you could theoretically be going on for years. Here in Minnesota, we had a very drawn-out estate fight over Prince's estate because he had died without a will. And not only were his family members trying to fight it out, but also the IRS wanted their tax cut as well, so that added more time and complexity to the matter. So how long it takes really depends upon how complex the probate ends up being. And so then we've seen the steps, we've seen how long it takes. Your next question is probably, can I avoid all this? And the answer is yes, you can. There's 3 main ways we can do that. The first is we can work with trusts. So if we have assets that are owned by a trust, they're not titled in your personal name. Those assets don't necessarily have to flow through the probate court and be distributed. They don't have to be part of the filings. Your trust can actually do the distribution for you and have the assets go to who you're planning on them going to. The second thing you can do is have joint ownership with the right of survivorship. So for example, if a husband and wife are married and they own a home together, when the first one dies, the home doesn't have to be sold. It just goes to the living spouse 100% through a right of survivorship. It does not have to go through probate court. However, when that second spouse dies, if the house is still in that spouse's name, then at that time the asset will have to go through the probate court. And number 3, what we can do is use transfer on death designations. And what these mean is that you have a designation, whether on property or a beneficiary designation on an account, which says that when somebody dies, the account, the asset goes automatically to somebody else. It does not have to go through the probate court. And when we're putting together our estate plan, we want to work with our financial advisors and use that transfer on death designation where we can, so we can simplify the probate process. So as you can see, there can be a lot involved with probating an estate. If you have more questions or you have some questions about creating an estate plan to help you avoid these probate issues, you can go to my website, 𝙃𝙀𝙍𝙀𝙁. There's a red legal strategy session button on the front page. Click it and you'll be taken to my personal calendar. We can set up a strategy session, a 15 or 20 minute phone call. We can go through your questions and help you get your estate plan set up to avoid probate as best we can. If you like this video, you can hit the like or thumbs up button below. You can go over to YouTube or 𝙃𝙀𝙍𝙀𝙁 to watch out for future videos. And if you have more questions about the probate process, feel free to reach out. It can be a very confusing process if you've never been through it before, but it's important that you understand it.